Welcome to today's coffee break briefing. I'm going to be talking about the changes to Companies House procedure and giving some suggestions to you as insolvency practitioners about what I think you might be doing now to start preparing for them. So first question is, what reforms are these? They are being brought in by the Economic Crime and Transparency Act 2023, or ECTA as it is known to its friends, and that's a piece of legislation that will make a lot of changes to the Companies Act 2006, particularly in the way that Companies House is regulated and run. Some of the first changes came into force at the beginning of March, and there were some more minor changes that came into force at the beginning of May. The big changes are all yet to come, and we don't have a timetable for them just yet. I'll take the opportunity now, though, to mention that the Policy Director of Companies House, Stuart Morgan, is booked to talk at the CESCA conference in September. So suggest you might want to save the date for that, as that will be a good opportunity for you to ask him some questions about the timetable for implementation and how it might affect insolvency practitioners in particular. What are the reasons for the changes? Well, there are a couple of main ones. One is to improve the reliability of information kept at Companies House. Traditionally, Companies House has just filed everything that has been sent to it, and Companies House has been a record of the documents that have been sent to Companies House about a particular company. There's been no guarantee that those documents are necessarily accurate or filed by people who are entitled to file them. And one of the other changes, which is, I suppose, to try and remove one of the consequences of that way the Companies House has traditionally been run, is to make it harder for criminals to set up companies for nefarious purposes. What I'm going to do now is give you the summary slides at this point, just so that you know what it is I'm going to be talking about, and I'll repeat them again at the end of the presentation. I've got 3 suggestions for you, and there are also 5 points that I think will be of particular interest to insolvency practitioners. Start with the 3 suggestions. First one is that there is going to be a registered email address for every company. This is already in force. It's a bit like the registered office that companies already have, but email rather than postal address. Second thing is, I think that insolvency firms will have to decide whether they wish to register themselves at Companies House as authorized corporate service providers. A lot of professional service firms will be doing this, and these organizations, the ACSPs, will be, if you like, gateways to Companies House. They will be private sector organizations with the right to file documents on behalf of other companies. And my guess is that probably a lot of insolvency firms will want to set themselves up as ACSPs, but it's something I think you'll probably be wanting to think about right away. Third thing is that you will need, when the time comes, to have procedures to verify ID on those occasions when you need to, when you file documents. It'll be rather like the procedures that you have now for verifying client identity with the onboarding procedures. It'll just be for one further purpose that you'll need those sorts of ID checks. So those are the 3 things that I think you're going to need to be thinking about. And there are 5 things that I think you will find of interest as an insolvency practitioner. First one is that companies, smaller companies in particular, will have to file accounts that will contain more useful information in them, which I think will be a good thing as far as we would be concerned. Second thing is that the record of directors kept by Companies House will be considered to be definitive, and that's going to replace the statutory register of directors that until now companies have always had to keep. There will be some more restrictions on disqualified directors, and I think that one of the possible unintended consequences of these changes is that we might see more businesses, particularly small businesses, setting themselves up as unincorporated businesses, more sole traders, more partnerships. Final point I'm going to be mentioning is something you've perhaps already seen in commentary about the legislation, that companies will have to file a lawful purpose statement every year, and indeed when they first are incorporated. And I'm just going to say a bit about what that is all about, what the reason for it is. So I'm going to start with the first of the three things that I think you're going to need to be looking at, and that is the official email address. And this is going to be similar to, in concept, the registered office address that companies already have. Companies will still have to keep a registered office address, which will have to be a postal address, and it will have to be a legitimate, genuine postal address for them. There have been situations of companies being formed with registered offices where the people who have responsibility for the registered office have no idea about the company that is squatting on their address. That's another topic. I'm going to be talking about the official email address. It's a little bit different from a registered office in that the registered email address is only for Companies House to use. You don't have to notify it to anybody else, and it's probably best practice not to publicize it generally, but just to reserve it for Companies House. Companies House will know what it is, and Companies House will use it. So if they have any documents, notices that they want to file, perhaps a warning that they're planning to strike the company off, that will go to the registered email address that they have got for the company. This is already being phased in. This is one of the reforms that took effect at the beginning of March, and it means that all new companies formed since then have had to give an official registered email address to Companies House on incorporation. All existing companies are now having to do so as they file their annual confirmation. They're all having to give an official email address to Companies House. So I think this is something that you will want to add to your appointment checklist, if you haven't already done so, is the need to change not only the registered office of the company when you're appointed as a liquidator or administrator, but you will also want to change the official email address that they have got lodged at Companies House to an email address that you have got under your control. Now, to change it, there is a link on the Companies House website to update a registered email address. You will have to sign in to use it. Now, I'm assuming that Companies House will allow a newly appointed liquidator or administrator to do that. Again, you might want to make sure that your appointment checklist does include getting the login codes for the Companies House account if you don't already have that. There are some decisions that you will need to make about your procedures for the official email address. For example, would you want to use one email address across the firm for all companies in your portfolio, or would you want to have it being an email address for the named office holders on that particular case? Would it be a generic email address that you set up if you're going to have one email address that's used for all companies in your portfolio? And the recommendation, or the advice is that you don't have to give this email address to anybody except Companies House. And the recommendation is probably that in that case, it's best that you keep that as a private email address known only to Companies House, if at all possible. So that's the registered email address of the company. I'm going to talk about authorized corporate service providers, ACSPs, who I described at the beginning of this presentation as being effectively gatekeepers to Companies House, people through whom companies will be able to file documents when they want to do so. This is not yet in force, and to be an ACSP, you will have to apply to Companies House and be registered with them on that basis, you will be authorised to verify people's identity, and Companies House will rely on identity that's been verified by an ACSP. They're likely to be professional service firms. They will be allowed to file documents on behalf of others, primarily your clients, I would think, and possibly those companies over which you are appointed. And the precondition for being an ACSP is that you have to be already regulated for money laundering purposes. So, as I say, it's likely to be professional service firms, and it may well be insolvency practitioners who will register as ACSPs. Will you have to register as an ACSP to be able to file appointment documents and so on at Companies House? I don't know. I don't know what specific arrangements there will be for insolvency practitioners to file documents. It might just be easier to be registered as an ACSP and to use that as the basis for filing documents at Companies House. Identification of people is going to be really important under the new regime, and somebody who needs to file stuff at Companies House will have to verify their identity, and they can either do that directly with Companies House or they can do it through an ACSP. I've lifted this diagram here from the white paper that was published a couple of years ago. And the essence of it is that Companies House will be a register not only of companies, but they will also be a register of individuals. And people who are directors or who have significant control of companies will have to have a personal account at Companies House. And that personal account is one where they will be verified, and that means they will only need to be verified once, because that personal account will then be linked to all of the companies of which they are a director. And again, I think that one of the things that we will see as a result of this is you sometimes see a director who could be a director of numerous companies, and Companies House have not always made the link that this person with this name and this address is the same person as is also a director of these other companies. That link is now more likely to be made in the future. Identification will be with something like a passport or a driving license and a mugshot. So it's very much similar to client onboarding identification procedures that we all know and love as at present. Again, I've lifted this diagram from the white paper, which just shows how it works. There are no surprises there. So, as I say, it may be easier to file post-appointment documents at Companies House if you are an ACSP. It almost certainly will be easier to file pre-appointment documents at Companies House if you are an ACSP. So I think probably for a lot of insolvency firms, they will think that it's just going to make life easier for themselves if they are registered as an ACSP to give them a general authority to file documents at Companies House. I'll move on to talk about ID verification. I won't say an awful lot about it, other than there will be another chapter in your office procedures manual about this, because you will have to keep a record of exactly who it is, which individual has filed documents when they do so, and their specific authority to do so. It may not be particularly onerous, but you will need to keep records on that. And this is something to look out for, to look at the detail as and when this requirement comes into force. So those are the three things that I've suggested that you're going to need to think about. I'll now move on to look at some of the issues that are perhaps going to be of interest, that are not things you need to make particularly strategic decisions about. And one of them is the changes to statutory accounts. And this is being done with the intention of improving the quality of accounting information that is on the record at Companies House. And it particularly affects small companies and micro entities. Small companies will have to file complete accounts, so they will have to file a profit and loss account and a director's report. Similar requirement for micro entities who will have to file a profit and loss account in the future. They won't have to file a director's report, and I imagine that probably many of them will choose not to do so. I haven't dived into the detail of these changes to see if there's more significant changes to the information that will have to be disclosed in accounts, but those are the headline changes. And the implications of that for insolvency practitioners, I think if we're going to have better information on the public register about the financial performance of the company pre-insolvency, and that may help us to assess what has gone wrong and why, and it might also help us to assess whether there are claims against directors, particularly if we're looking at things like unlawful dividends, for example, directors' loan accounts. Moving on to look at the records of directors that Companies House will keep, there is a big change here in that the existing statutory register of directors is going to be abolished. The Companies House record of directors is intended to be the definitive record, so there won't be any need for companies to keep their own private registers of directors in the future. Every company will have to have at least one individual who is linked to them through their personal account at Companies House. And that person is likely to be a director. If they're a person of significant control, they're also likely to be linked to the company in that way. It will be harder for companies to have corporate directors. It won't be impossible, but the corporate director will have to be incorporated in the UK. It will not be possible to have an overseas company as a director of an English company. And all directors of the corporate director must themselves be human. It's a one-level rule. You can't go up above that and have corporate directors of a company that is itself a director of another company. If a company is a director of another company, then the company which is the director can have only human directors, cannot have any corporate directors itself. Once somebody has been appointed as a director, under the current arrangements, the law as it now stands, once somebody has been appointed a director, they are a director as soon as they are appointed, and they have a few days to register their appointment at Companies House, but they are a director from the moment that they are appointed. That's going to change in the future, and that somebody who is appointed as a director will not be entitled to act as a director until they have been registered at Companies House. And to be registered at Companies House, they will of course have to prove their identity to Companies House, either directly or through an ACSP, according to how they're going to do it. Now, this doesn't mean that somebody who is appointed but is tardy in getting themselves registered, that doesn't mean that anything that they do can be set aside as ultra vires beyond the power of the company. If they've signed a contract purporting to act as a director, even though they haven't been registered at Companies House, that contract will still be valid. Now, they themselves may be responsible as a de facto director, somebody who is genuinely a director, although not legitimately appointed as a director, or they might be a shadow director. And by either of those capacities, they are potentially legally responsible for anything that they do whilst acting as a director, even though not legally appointed as a director. There are criminal sanctions for them. There are criminal sanctions for the other directors who are complicit in allowing somebody who has been appointed a director to do stuff as a director before they've been registered. So these two rules work well together in that the identity of directors will be verified, and somebody who is appointed as a director will not be able to act lawfully as a director until they have been registered at Companies House, which means that they will not be able to act lawfully as a director before they have had their identity verified at Companies House. And as I've already said, the public record will be considered definitive. I'm not going to say a great deal about disqualified directors. I'll just put these slides up so that you can see them. It's essentially that disqualified directors will be automatically removed rather than having to resign from office, and that when a company is formed, the first directors have to formally confirm to Companies House that none of them are disqualified and that nobody with significant control of the company is disqualified either. That's a bit about sanctions that Companies House have got for unverified directors, which is a bit like being a disqualified director in that you're at risk of criminal proceedings, civil penalties. The Companies House could refuse to accept documents sent for filing whilst there is an unverified director running the company. And you might find that there are consequences with third parties. It wouldn't surprise me, for example, if banks felt that they had to freeze the account of their customers if they have an unverified person acting as a director of it. So we seem to have a question. Let me see if I can. Yes, this is just a comment here from Mark Littleton, just saying that the reintroduction of profit and loss accounts effectively is taking us back to where we were in the 1980s when companies were first released from the red tape of having to file full accounts. So is it a step forward? Who knows? It probably is actually. It probably is useful to have that additional information, but it's going back to where we were before. So moving on from disqualified directors, and as I said at the outset, I think that one of the possible unintended consequences of these changes is that they could actually deter people from incorporating as a company or other type of entity, because these reforms will apply to, for example, LLPs in the same way that they apply to companies. And it could be the additional cost of having to prepare more detailed accounts. It might be the additional cost of having to comply with Companies House rules, or it could be the additional cost of penalties and such like from failing to comply with rules. And it might be that directors might think, if they've had some experience of the consequences of failing to comply, they might just want not to deal with Companies House in the future. And I think professional advisors will have to think as well of how much of a benefit is limited liability these days, given how many personal guarantees directors are asked to sign, and how many companies have overdrawn directors' loan accounts when they go into a formal insolvency procedure. So I think we might see in years to come more people doing business as sole traders, as unincorporated partnerships. And perhaps I ought to cover in future coffee break briefings something about partnership insolvency and possibly trading IVAs as well, and how those should work. And I'll move on to look at the lawful purpose statement, which has attracted a certain amount of publicity. And when people want to form a company, they will have to state that they are forming the company for lawful purposes. That'll have to be something that they attest to Companies House when they first set the company up. And in every annual return that is filed, every confirmation statement that is filed, the directors of the company will have to say that the intended future activities of the company are lawful. Now, you might well think that somebody who is setting up a company to run something like a carousel fraud, for example, they're not being given the option of ticking that particular box and telling Companies House that that's why they're setting the company up. But they don't really get a choice about it. So they're unlikely to flag to Companies House or law enforcement that they have actually got an illicit purpose for the company. So the reason for this is really because it will now be an aggravated offence because there is a deliberate misstatement on an official document if some sort of action is taken against the directors for fraudulent trading or something of that sort. And also, Companies House have got extended powers to strike off companies. And one of the grounds for striking a company off and dissolving it will be if there was a false statement made in the application to form it. So you might find that Companies House would have the power summarily to strike off and dissolve the company that has been set up simply to participate in something like a carousel fraud. And from our point of view as insolvency practitioners, we might find ourselves thinking about whether this sort of misstatement might possibly give rise to a claim in the tort of deceit or something like that. And we might well find ourselves looking back at confirmation statements to see if we can build a case on the statements contained in them. So that's covered the main points. I'll just go back to the summary slides and just go through them again, just to remind you of the points that we covered. So the three suggestions for you, firstly, is about perhaps having a single official email address that will be the registered email address for every company in your portfolio. Second thing should be to start thinking about whether you would want to register your firm as an authorized corporate service provider. And I think we'll probably need to see a little bit more about the detail of how that works. But my feeling at this stage is that probably it will make sense for many insolvency firms to register in that way. And the third one is to be ready to set up formal procedures to verify identity when you need to do so when filing documents, and to make sure that that is all properly documented and recorded. Now we seem to have frozen here. So I'll try and cover from memory the 5 further points that I was talking about, and that is to be aware of the changes to Companies House, and so to be aware of the changes to accounts that are being filed at Companies House, and the fact that we will be getting better information in the future. The need for directors to verify their identity, and the way that the Companies House will be running a single personal account for everybody who is involved with companies at Companies House. I'm going to have to ask you to go back to the slides at the beginning, I'm afraid, because these are all now frozen and I can't move these on at all, so my apologies for that. We have got to the end. If you've got any questions, please do ask them now, and I will try and pick them up if you've got any. Other than that, just to remind you of some future dates to be aware of. First is the Southwestern Insolvency Conference. I'm not involved in that. I think that's the 18th of May. If you would be interested in attending it, then drop David Kirk an email about it for information. There is our insolvency conference on the 7th of June in Brockenhurst. You should have had an invitation to that. Hope to see as many of you as possible at that. There is an R3 regional meeting on the day before that, on the 6th of June in Reading. And there is the SESCA seminar at Denbies. I think that's the 25th of May. I will be talking at that. there is the SESCA conference at Reading, which is the one I mentioned, where we've got Stuart Morgan as Policy Director of Companies House, is going to be talking to us about these changes. It will be a good chance to ask him some further questions. And there is the SESCA seminar in October at Denbies as well. So with that, with apologies for the screen having frozen, I'll now bring this to an end. I won't see you online next week, but I do hope, next month, sorry, but I do hope to see as many of you as possible at our conference. So thank you all very much and goodbye.